Conferencia magistral. Aurelio López Tarruella Martínez. Doctor en Derecho. Profesor titular de Derecho Internacional Privado en la Universidad de Alicante, España. Director de la Cátedra OEI-UA de Cultura Digital y Propiedad Intelectual. Consultor para la OMPI, la Comisión Europea y el Parlamento Europeo en materia de propiedad intelectual. Profesor, entre otros, del Doctorado Europeo IPIN, Innovation Society, del LLM in Law of Internet Technologies de la Università Bocconi, Milán, Italia, y de la Maestría en Derecho de la Propiedad Intelectual y la Competencia de la PUCP, Lima, Perú. Fundador y director de Lucentinus, blog de propiedad intelectual y tecnologías de la información. Ha sido abogado of counsel de Beilos, FGF Legal y Salvador Fernández y Partners. Autor de gran número de publicaciones en el campo de la propiedad intelectual y el derecho digital.
Good morning to you all in Latin America. Good afternoon to those in Spain. It's a pleasure to be here today. Thank you very much for having me. I would like to thank CP and Luis Enriquez. And we have been exchanging emails, and it's an honor then to share some ideas about a topic that I have selected. So we are talking about intellectual property issues for small and medium-sized enterprises, SMEs. So this is a topic that is wide enough. I mean, we can spend 2 days talking about this, but I'm going to focus on some aspects that are important to me, both from the academic standpoint. And I also believe that these issues are taking place in practice. So this gathers the academia and also practical aspects that I believe are important to some of you. There are councils too. So after this incredible presentation, I'm going to go right into the presentation. I would like to highlight the aspects mentioned about the Inter-American Department on Digital Culture and Intellectual Property. There are some opportunities. So if you feel like contacting me, you can use LinkedIn, because probably we have people in the audience that are interested in these grants for studies on intellectual property. And also, as you can see, there are some other activities organized by the department that we'll be sharing to all the ACP staff. What I wanted to tell you about in this lecture basically can be summarized in 3 statements. So this will take 30 to 40 minutes, so then we can have a Q&A session of 20 minutes. Just in case you have questions, doubts, or comments to share about this topic. And believe me, it's going to be a pleasure to answer all your questions. A concept that I would like to highlight from the academic standpoint. So basically, we're going to be talking about the democratization of technology. So basically, this offers great business opportunities for startups in general, and for Latin American startups in particular. But while generating new business opportunities, this also implies that there are new issues that have to do with intellectual property management that are new because they were not important up to now. And that was not that present for us practitioners of intellectual property. And now they are playing a central role. And we need to start paying attention to them so that we can provide the right advice to our clients. So as you can see, there are 3 steps that I would like three areas that I would like to cover during the presentation. So what do I mean by democratizing technology? First, I would like to distinguish the benefits of digital transformation that can be general to all types of businesses. And also, these are the phenomenon of technology democratization. So if we look on the net, we can find different concepts for this term. I'm not going to expand on the concept, on the definition of the concept, but I would like to highlight how this phenomenon represents new opportunities to SMEs, startups. So that's why this concept is basically to reduce barriers that are present in the access to technology. So this may be companies, SMEs, or just the general public. And these barriers are going down due to 5 factors. First of all, internet is more and more accessible to more people. Also, storage and processing of data is cheaper and cheaper. And also, there is an increase in the offer of free open source software, an increase in the volume of data of this information, of this open source information. And the last one, that is the process of using standards and the role played by standards when it comes to interoperability between different technologies. Due to the relevance of these aspects to IP, I would like 3 of them. The first one probably has no connection with the rest of the issues that we're going to be discussing later, but it's important that you understand this idea because it's an important part of this process. What we're witnessing now is the reduction of the cost of technology access. And basically, this has to do with Moore's law. And the idea of transistors within a circuit, if you double that every 1.5 years, that implies not only increasing storage capacity and information processing of the devices, but it also implies a significant reduction in the price that you have to pay for storage and for data processing. Also, these together with specific software for the treatment and processing of large amounts of data, we're here in a situation in which our computers do not need to store data because those services now are available, and basically we can pay for those services because those services are provided in the cloud. This cloud possibility generates and increases competition in the market, and now companies can provide services regardless of their geographical situation. So that increases competition. Now these services are available everywhere. Prices are going down. We have different and new business models. But together with this reduction in cost related to processing and storage, we have another second phenomenon. And that is the fact that a large amount of the software used for the management and treatment of data, that is open source software. Starts with MapReduce, Hadoop. Then Hadoop was created by Yahoo. And after that, we have a whole new ecosystem. Not all the examples that are on this slide are open source, but most of them are. This has significant advantages for startups because now you can have this software for free, and at the same time, it has a community also available, and that increases effectiveness, and everybody benefits for that. So access to this technology, and it also leads the way in artificial intelligence or blockchain. You don't need to generate this within your company, but it's available to everyone. Together with this, then, and in the third place, we have what people call this new oil, or the fourth industrial revolution. That is basically data. I love this statement here. We don't have better algorithms, we just have more data. And that is a quote by one of the engineer leads of Google. And that represents the importance of access to large amount of data when it comes to provide better services based on data, and also to develop artificial intelligence tools. And once again, and we're talking about the same idea, right now we have large amounts of information, and of course there are companies that are larger than the rest, like Google or Facebook, but there are large amounts of information that is available to all companies for this purpose, basically to provide analytics services or to develop IA tools. Here we have like different databases. This example here was generated at a university that is owned by Google. We have another database created by Fei-Fei Li in the University of Princeton, and that was a revolution when it comes to image identification software, or the example of Wikipedia, that is one of the most popular tools for artificial intelligence models for language. All this is information that is open sourced and is free to access by everyone. Everyone can benefit from this, large companies or small companies. Together with this, we have large amounts of information that is available to all companies, and that is done by the governments. For instance, here you can see on this slide, you can see the data catalog that is available in datos.gov.es. That is the data website of the government in Spain, and it classifies all the data of all the different ministries of the government, and that also happens in other countries. And also in the region, in the Latin American region, we also have websites of open source data from the different governments. All this represents a reduction in the cost of the possibilities for research in technology. And now it's not necessary to have some internal research to have access to all this software, because it's basically open source and available to everyone. And you have no restrictions whatsoever regarding location.
This, of course, allows SMEs and startups compete in the digital market with equal opportunities in comparison to bigger companies that have more funds to spend. So, this is a huge opportunity for startups. And additionally, this is a component that relates to the market. That is that from the moment that we're playing on the internet, the market is no longer national. The market, of course, becomes regional or even global. And what I would say is that if I am limiting the scope to a regional market, I am doing it because of the advantages that we have if we share the same language, or 2 or 3 languages, if we consider Spanish, English, and Portuguese when we are offering digital apps or digital services as startups. So I think that at least at the beginning, we don't have that many obstacles like the obstacles that we would have in Europe, because even if the digital market is the same, we have 23 languages that coexist, and we have at least 23 different cultures that we should be catering for. So this is something that we should bear in mind. And if we look at the data, what we see is that these opportunities are being leveraged by SMEs. We have significant examples of unicorns in Latin America that come from multiple countries in Latin America. We're talking about SMEs that have reached a value of over $1 billion. But I think that another interesting thing is, if we look away from the success stories that are 1 in a million, is for us to look at this chart that you have over here to the right of the screen that has to do with the infomedia sector in Spain. And what you can see over there in this chart is that the companies in the infomedia sector in Spain are at least small or micro companies in Spain. We're talking about half of the companies in the infomedia are micro companies. So if we're talking about this case, we can even reach 94% of all companies in the sector that are SMEs. So there are companies, there are entrepreneurs who are realizing of the possibilities offered by the sector. And because of that, they're launching very successful businesses. And for these businesses to succeed, I think we can all agree that we do need to properly manage the multiple aspects of intellectual property. And these are aspects that, in the way that I see it, and when I work on different classifications, I always tend to classify these aspects in a very subjective way. So, in that sense, I might be wrong and we might not see eye to eye, but I think that all of our opinions might be valid. But what I would say is that there are traditional aspects, and then there are new aspects and issues that arise for these tech startups. At the traditional level, we're talking about registering brands, trademarks, or industrial designs for startups. We can also talk about content protection that might be protected through copyright. Perhaps we're talking about copywriting the content of the website. We can also talk about software protection, either through copyright or perhaps through a patent. And then the new issues that we're facing, in my opinion, are those that precisely arise because of something that I will later on mention, which is that this FOSS, which is free open source software, now occupies a key role when the solutions are being designed and developed, or when the services provided by these startups are being designed and developed. So the questions that these startups might start asking themselves is, what kind of software can we use? What are the conditions that the software needs to comply in order for them not to infringe on a patent or infringe on the FOSS that is available in the market? But apart from that, they should also bear in mind that the company should not only be told this software is good and you can use it, or this software cannot be used, but the advice that we should provide for them is, if you use this software, this is how you should design your business model in order for you not to infringe on a patent. So what are the things that you can do not to infringe on a free software license in order to provide an innovative service that will provide benefits within the market? So these are the issues that I find to be new. And then there are other similar issues that come up based on the data that I mentioned for the market. So what is the data that is available in the market that I can use, and under which conditions can I use it? How can those data affect my business model as a startup? But also within this aspect, I think another thing that we need to include is the matter of data protection that is generated and that are generated from the apps created by the startups. This is something that is being widely debated in Europe. And what I would say is that perhaps we are debating this a bit more than we should. But undoubtedly, this is something that we do need to ask ourselves. And the questions and the answers for those questions are sometimes more simple than perhaps we might understand. And then another aspect that I think is novel is the aspect of the interrelationship between data protection and the protection of data as a new intangible asset of this company and the regulations on personal data, because sometimes the data that belongs to the company and that provide them a competing edge in the market is data from users or clients. So even if they give them a competitive advantage within the market, the regulation on personal data privacy forces those companies to bear into mind and to use those data under certain condition. And of course, these are things that as counselors, we have all thought about when we're talking about the design and the implementation of a business model, rather than things that we think about when a controversy arises. So the question as to whether using open source software is something that we ask ourselves when the business model has already been deployed in the market, then it will become harder for us to solve the problem. Because of course we might be looking at the infringement of a license, and the only thing that we can do is to negotiate before getting to a litigation. And that might actually be a result that many of us here have dealt with in the past. So I think we need to create a culture in which startups contact intellectual property experts before they start designing and implementing their business model. Now I want to move into discussion of the issues that I see with the use of open source software, and then I will talk about the problems related to data. Now, with regards to FOSS, I think that some of you that are listening to this presentation, you might say, hey, he's saying nothing new, right? Open source software has existed since the late 80s, and it has evolved, and we all know how that software has evolved. And we know that a multiplicity of licenses have come into the market. But what I would say is that after 2018, we did start seeing that this open source software is a feasible business model. There are many companies that started trading in the stock market and became public. And that particular moment, I think, is a pinnacle for the FOSS, because they became more relevant, but they also became more complex. They became more relevant because currently developing software that is not based on FOSS is practically unthinkable. Actually, statistics show that 79% of corporate software is open source software. And then if we also look at leading edge technologies like blockchain or artificial intelligence that are very much relevant in the market, they are also based on open source software. So the relevance increases for this software. So a software that was residual before and there were only a couple of companies that were using it change, and right now every tech startup needs to use this kind of software in their business. They either need it or they can attain a great advantage both in the technological aspect as well as in the cost reduction aspect. And then another important element is the complexity of this, because now we have a great diversity of licenses. Many a times these licenses are not written using legal terms, so the council faces a license that it was written by an expert, a technical expert, and it's sometimes really hard to interpret what the license means. And this, of course, also correlates to the fact that we do not have too much case law that is relevant to those licenses. And as a matter of fact, a couple of days ago, I was very much surprised by a case that I found in France that studies issues with the creation of case law for these startups. And this complexity also implies that we cannot think of open source software as a copy paste clause. The variety is great. There are multiple licenses that we refer to as permissive licenses, because they allow for people who use the software to then use them for their own business and actually sell them. And even in those licenses that have a copyleft clauses, which are licenses that force the derivative work that was that was created using that license, are also present. And this is something that we should bear in mind when we are determining a business model. If we're talking about a company that wants to develop a new app based on open source software and then distribute it, then they might see that they will not be able to deploy that business model if what is included in that software, or if that software itself was created based on a software that has a copyleft clause that forces that any copy or any derivative application be distributed under the same license. Now, we may come across over here with the first questions for the interpretation of a derivative invention, and the difficulty of seeing if it's that or it's just an addition to a software. That's a complex issue. There's another issue that has to do with the definition of distribution. When we're talking about distribution in copyright, does not mean the same in the US that it does in Europe or even in Latin America. As a matter of fact, in Europe, after the use of decision and ruling, it was considered that downloading something from a website is an act of distribution. Does this happen everywhere? Well, we'll see. And does that mean that in those cases we're not talking about distribution? Well, we'll also see, because the concept of distribution used for the GPL license is thought of, according to US case law, in one particular way and might be applied in a different way in other jurisdictions. So, if we're looking at a company that cannot distribute software because they have used software under a copyleft license, they might think that rather than distributing the software, they might have a business model that seeks to develop tech solutions for other companies. So rather than sell software, what they do is they install that software within the servers of another company, or they might provide a tailor-made solution for those companies. And that would be a valid business model that would not infringe on any license that might have a copyleft clause. But even in those cases, we should ask ourselves, what is the mission of that company? Because if what you are developing is a software that that company uses at the internal level, but then wants to sell it afterwards, or might even want other affiliates of that same company to use it, we might find that that company is infringing upon that license. And then it would be interesting for that company that created that software to then be exempt of all liability. And of course, in that case, IP councils will provide advice on what to do. And then lastly, we come across a possibility that nowadays is very much possible for everyone because of the existence of cloud service, because many times we can have software as a service options. We know that for the GPL license, it used to have the cloud services loophole. This loophole for the service, people sometimes call it the Google loophole as well. Because what happened was that when that software was offered at the remote level, it was not being distributed. So the company that was using it and modifying it would then not be obliged to divulge the source code of that derivative invention. So they are benefit from all the contributions of that open source software, but at the same time, they are not forced to divulge their contributions to that open source software.
In these cases that were considered unfair in many cases, we know that the Free Software Foundation adopted license 0 GPL, and this license makes it compulsory to share the source code even in those cases where the derivative work is not distributed, but it's made available to the general public remotely. So these are clause that includes a very strong copyleft. But even in these cases, in 2018, we started seeing that some stakeholders of the free software market consider that this license is not enough. This AO license only makes reference to the modified version of the open source software. So they create a new license.
Licencias, un ejemplo.
They are creating new licenses. For example, the SSPL. Another one is the Elastic 2.0 license, where they basically includes more stringent conditions for the use of these, or the remote use of this software. And here, again, we need to be careful with the diversity of the licenses, because that increases every day. And when we provide advice, we need to provide advice to a specific license and try to avoid open source licenses. If we cancel that, we need to specifically see which license we are talking about, what kind of license does the startup want to use. And then we provide advice about what to do, what not to do when designing the business model. Something similar happens with data. With the data that startups find on the internet in order to use it in the data analytics or to generate tools for artificial intelligence. Before that, however, we need to analyze the situation in Europe, and I think it can be replicated in other parts of the world when it comes to data protection, that can be generated by the startup itself. For instance, let's imagine that we have a startup that has an application to be downloaded by the users that will generate a lot of data. And thanks to those data, the app will increase in value. And thanks to those data, the startup then will be able to offer tailor-made services. How do you protect all those data? In Europe, they have discussed the fact that they cannot use copyright for data protection since it's a database that is not original. Those data were automatically generated.
Por lo tanto, es una base de datos que
So then it's a database that when it comes public, it won't be protected. And the fact that it is not protected then is what happens with many databases that are available on the net. And right from the beginning, that can come as a surprising fact. For instance, I don't know, the schedule for a football match or the schedules and the results of the NBA or the baseball matches. If we consider that from the European standpoint, that is very difficult to protect using copyright. And then it's also very hard to show that they are original when selecting and presenting those data.
se creó un derecho.
That's why in Europe they created a specific law, that is a sui generis law. And even though it is used in the presentation and selection of information, it is not applicable in those cases when we are talking about data or information that was automatically generated. Lastly, if we also consider, or if we add more questions about how this data are protected, then we need to take into account which is the law that we're using as a reference. We can have a startup where those data are available. Let's imagine they have a website and data is available. So how do we know if those are protected? According to which law we define that? Another issue regarding data has to do with the use of data that the startups find on the internet that are open access. So this is a trend that we have observed and that started a couple of years ago. And this is because institutions of the academia or big companies like Google, for instance, they want to publish open access information because that may be an advantage for research in some areas. So, and also some companies, of course, get a benefit from this. This trend of private actors also something similar happens with the public organizations. For instance, the European Union or Obama government or the UK government, they do believe that the more the data available for the general public, then the more we are contributing to the innovation sector to improve the society as a whole. That's why we find open access policies that aim to publish all this information by the bodies of the public area. Or we also find these kind of policies in areas related to research agencies. In those cases where they generate research data or they publish about research results and they are using public funds. In that case, it is mandatory for them to publish all that information in an open access information so that everybody can benefit from that. Once again, here we find an issue of complexity. Why? Because publishing all those data there are some licenses attached to those data. It is true that the licenses that are used for open data publishing are not as complex as the ones in software, in open source software. I could say that likely this contributes to make conditions easier when considering the use of data. And also now we have licenses that are very general. However, there are some differences, especially in the different versions of the Creative Commons licenses. There's a new type of licenses, Open Data Commons, that may generate some diversity. And together with this, and I think that this is the most dangerous aspects of all this, is that since we have some information that is offered by the public authorities, then we have administrative law involved. And in some cases, they set some general conditions for the use of that information. And those general conditions are not related in any way to these licenses that are well known and may make it more difficult to use them. The complexity of these licenses is also defined through the interaction with open source software. So as a way of example, I can tell you about, for instance, a company that wanted to use a pre-trained model of machine translation that was under an MIT license. That is a permissive license. Basically, the license allowed them to adapt the model, and then they could sell that. What happened? That the pre-trained model, in order to adapt that model to create a new model for the simultaneous translation of Italian, they use a database that is under Creative Commons non-commercial license. And the question of the startup was, can we sell this model that we have adapted for Italian translation? The answer is a complex one. You may think that since this will have a commercial use, and probably the answer is no, because you are infringing on the Creative Commons license. But the thing is that if they have created another piece of work that is a derivative from the other one, so now we have issues that are not that easy to solve. And there are also some issues related to the interrelationship with personal data. The best example I can share is the situation that happened to IBM when they were training an image recognition AI model. So they went to the Flickr database when basically people upload pictures, and people upload those photos using a Creative Commons license. IBM made two mistakes. First, they thought that the Creative Commons license is only one. They didn't know, because there was a clause there about non-commercial aspects of the license. And the second mistake is that many of those pictures were showing images of people, so they were personal data. And for that, they could have needed the consent of these people to use those pictures.
And it is true that an issue arises here, which is which law should be considered as a reference in order to consider whether that personal data has been illegitimately used. When we are part of a company that offer services in multiple countries. And to this, I would say that this particular case has already been covered by this open data regulation, especially with regards to public government informations, because the regulation already establishes that it is necessary to make that information anonymous so that we don't have issues with personal data. And now the last issue that I would like to deal with, and I will also deal with it, I will only deal with it if you ask me to do it, that has to do with mining text and data. And the only thing that I want to say, and you'll tell me if you want me to keep talking about it, is that I am always surprised when I find data releases and some text by the press, like this one that you have over here that refers to the GPT-3 company by Elon Musk. This GPT-3 S's that I read about immediately made me think about how this model had been trained. And the answer is very clear. Among many things that had been included was Wikipedia. And Wikipedia can be used when it's available under Creative Commons licenses. But Wikipedia is only 0.6% of all data used to train that system. And that is clearly stated there. They used any sort of information available on the internet. So what I ask myself as an IP counsel is, how is it possible for them to have used all of that information? Did they ask for every single person to own that information or had any copyright licenses over that information for permission to use it? Or did they use some sort of exception to copyrights? And then once again, we need to think about which is the applicable legislation. When we're talking about OpenAI, is a company that has headquarters in the US. So, of course, it was bearing into mind what the US law said. But what I think about is, could they have carried out this same system in a different jurisdiction, in a jurisdiction other than that of the US? And if not, can we then conclude that there are certain legislations pertaining to copyrights that somehow hinder the creation of tools such as this one because they are not adapted to tools such as this one? I wanted to leave that out there and just share this slide over here with you that has to do with conclusions. And the conclusions are basically about how to provide counsel for these startups. What I would say is that if you're dealing with startups that want to offer digital services, you need to bear in mind that FOSS and open data are going to be issues at the core of their business model. We're not talking about things that are not tangent, they are actually very relevant. These startups require counseling from the beginning, not when controversy arises, but they need counsel from the moment they're developing their business model. Third aspect, they need a holistic counsel. That is, that we're not just going to be providing counsel on intellectual property aspects. We will also be providing counsel on other aspects, such as aspects of data and personal data privacy. And then the fourth aspect has to do with the geographical location of the headquarters of the startup, because we see that there are certain jurisdictions that are more beneficial for legislation that protects data than others. So, in as much as the startup can choose to locate their headquarters in a country that will offer them more flexibility or more benefits, that might actually be favorable for the startup, even if, of course, the headquarters and the location of the headquarters will also imply thinking about other factors. And now over here, if you can see, I'm sharing some interesting links for you. But if you want, you can find me on LinkedIn and I can share the presentation with you. And once again, Luis, thank you very much for having me here today. And if you have any questions for me, you can ask them. I'm sorry that I ran a bit late, but we still have 10 minutes though. Yes, thank you, Aurelio. Thank you so much for showing with such clarity such a complex matter, pertaining to software and to the decision that the people and the entrepreneurs that participated in startups and their councils need to bear in mind with relation to personal data. And of course, the globalization now has a very relevant role for these companies because the council provided no longer depends on the country where the tech company has its headquarters, but we also need to think about the legal implications of the work that they do in any other jurisdiction. So I think you were able to very clearly indicate what were the challenges for those companies and for us as councils. And there are multiple questions that I think will hardly be answered in only one way. And I think that both time and case law and jurisprudence will probably help us figure out those answers in time. And I see a question over here from Juan Felipe Porta. And the first question is, are there any resources available where all the open source licenses might be collected so we can analyze them? Yes, if I'm not mistaken, you have the website for the open source initiative. It is a very easy to use website that has a list of all approved licenses. And you have the hyperlink there where you can see the full text of the licenses as well. But do note that most of licenses are there, but not all of them. And what I was saying is that as of 2018, we do see licenses that might be based on an open source solution are no longer considered open source licenses. They have not been included in that catalog, and they have actually not asked to be part of that catalog, such as the case for the Elastic license. So some licenses might be excluded, but for sure, this is a good way to start if you want to start looking at licenses. Okay, so the same person asked another question, and this is something that I think we're all curious about, is whether you could explain what happened in the case of IBM with the use of images for training a model. What happened there? How was this decided? Okay, so I heard about this because of an article that I shared in the presentation. Oh, no, I'm sorry. I'm lying. And let me do a bit of advertisement because I heard this from a really great academic from Latin America, from a blog called Tecnolama. So the litigation was solved out of court, and the case was that IBM did not think about anything else. They did their scheme strapping. They connected their computers to a website and extracted all the information. And I mean, if we're talking about Wikipedia, you have no issues there because everything is under the same license. But if you're talking about a database and a portal such as Flipper, where users upload pictures based on whichever license that they want to use, what happened is, from the perspective of copyrights, is that they were under an infringement of those licenses. And if we think about the other aspect that has to do with data privacy rights, you, Luis, are in the US. And in the US, of course, this is something that might not be as strict as in Europe or as in other countries of the world. So I think that they will not get into a lot of trouble. Perhaps someone would tell them off at the moral level, but nothing else. Yes, and a good settlement, maybe. Okay, I see a question here from Eugenia Contreras. Normally, several FOSS go into one development, which adds more complexity and implies that we need to be on top of new licenses. So are there parameters defined in terms of compatibility for FOSS licenses? No. Well, what I would say, strictly speaking, is no. First, because there is no case law for that. These cases are normally solved out of court, and if they're settled in court, it's normally something that doesn't take that long. So I think that what we can rely on are the facts or frequently asked questions within the Free Software Foundation or in other websites. But that's only the opinion of that organization. There is a council, a great council called Helen Micker, who says something that I believe is true, which is that, and do note that this applies for everything, either license compatibility or other aspects, is that licenses at the end of the day say what the project wants them to say, or at least what the project leader wants them to say. That means that if the person who is behind that software considers that you have infringed on a license, they will sue you. And that's what happens, and that's what counts, at least now. Okay, I have a question here from Ricardo Fisher. And he says, in which intangible assets would you recommend a startup to concentrate when they have limitless funds? What would be the most relevant aspects to bear in mind at the beginning? What is the ABC, if you will, that the startup needs to follow? Okay, what intangible aspects when they have limitless funds? Yes, at the beginning at least. Okay, I think that they should focus on developing software. They should focus on focusing. No, what I understand is when you have a startup that has limitless funds, what intangible aspects, what intellectual property intangible aspects should they be more mindful of at the beginning? I mean, obviously, in terms of licenses, in the terms of trademarks, do you have anything to say about that? Well, no. At the general level, I think obviously they need to focus on the trademark, at least in the sense of saying that when you're developing software, the protection is there already. You're not going to have to invest money on that, but you will have to invest money in the trademark protection. You need to hire a law firm or an agency to register that trademark. Of course, you might be focusing on patents depending on the software that you are developing, but we do know that software patents are both rather expensive and they come with a lot of uncertainty. So if I had to define something, I would say first start with trademark protection. Okay, and from your experience, what would you say are the 3 most common mistakes that you have seen when people provide counseling for these startups? The most common mistakes made by these startups at the beginning of their business. Okay, I would say that I've come across 2 mistakes, not 3. The first one has to do with not looking at licenses. I mean, you know, trying to do something once the controversy has arisen, once you are in the process of the litigation, right? You haven't looked at knowing whether or not those licenses are protected, and they have invested 2 years in the AI model. And I'm talking from a real case, by the way. This is a true event. And some other times this has happened in cases where nothing is written. So you develop software, but no one wrote a contract for it. So the question is, who is the owner of that software? And in Latin America, I think something that has happened is that you have this mode of working for hire, right? That was very successful in the US, where the company that hires a particular service and asks you to develop something is in fact the owner of everything. But that doesn't happen in Europe, because if you don't have an agreement to back up that work relationship, then if you want to make any modification to that software, you're going to find yourself in trouble. So when you as a council find that the company is in that kind of trouble, it's really hard to provide help. Yeah, I think that what we always try to provide as a recommendation is that sometimes what you see as a client as an expense is actually not. You're making an investment, because if later on, if you have to prove that you own that license, you will be spending much more money in the litigation, right? And then now, to wrap this presentation up, what would you think and how do you think the decentralization of technologies will affect the protection of intellectual property assets?
Well, that's a very good question. From the academic standpoint, so a little bit of theory here. Sorry about that. To conclude, I'm an private international law professor, so there is nobody listening. I generally say that is a subject in which we have problems that are fascinating, but solutions are disappointing. Why? Because if you tell a company, for instance, let's imagine a case. Okay, we're talking about data. So a company has data, and you can tell them, okay, as long as you store your data and you adopt some reasonable measures to protect them, it's going to be a trade secret. Let's imagine it's a company from Spain, but they can hire those services to Amazon in the States. But Amazon is not storing data in the States. Maybe they do that in India, or maybe they just distributed those data between servers in, I don't know, the Antarctic, in Canada, in India, who knows? So which is the law? Which is the applicable law that, in that case, to know if that data has all the pre-requirements to be protected? So the solution is always disappointing. And the answer always is, it depends. It depends on the place in which you make the claim. If you do that in Europe, then they're going to be using, or it's going to be under European law. If it is in Spain, it's going to be under Spanish law. But that is not an appropriate answer to the companies, because when they are making business, they need this security. They need legal security. Regardless of the place in which they are making business, they need to know that their data is going to be protected as a trade secret. So what is the solution then? Well, I'm sorry, but I don't know. Probably the solution is to have a global harmonization. But in this subject of international law, Article 40, even though it was written many years ago, that definition can be used for the European board and also to American regulations. I can't remember the name right now. But we can't go beyond that. that generates a lot of trouble. But solutions, as I told you, in many cases are just disappointing. And believe me, I'm an international law professor. We will need to, rethink the whole subject. That's why I'm telling you all these things, and I'm not talking about my subject. Okay, it was really, really interesting. Your presentation was great. And so we really liked your presentation. We prefer this and then having all the answers. So we know it's a complex issue. It's very interesting. And we're going to be talking a lot about that in the future. So Aurelio, thank you very much for being part of our seminar. There are plenty of comments. So congratulations on your presentation. Thank you very much. And we'll continue talking about this in LinkedIn. And thank you, Luis, for having me. It's been a pleasure. Thank you. Bye-bye.
Yeah.